Thank you very much.
Could I begin, please, by reading out a short statement?
I don't have video for anyone at the moment. It would be a good idea if I did.
My apologies, Your Honour. It's Tom Montague Smith here. I hadn't anticipated that we would have video, but I am just putting on a tie, just in case I made sure. So if you just give me 30 seconds, then I will do that. You also have Mr. Dylan Malone, who has a watching brief for Nasdaq Dubai. I think he is dialing in by a telephone though, so you may not be able to see him, but hopefully that won't hold things up.
Thank you very much. I see someone in by telephone, and Mr. Maguire, you are there, are you?
Mr. Dylan Malone.
Yes, Justice Giles. I'm here with Mr. Hamid Ali and Ms. Doris Kayode of Nasdaq. We're all in one room and we're on the telephone, which is sufficient for us.
That's good. Yeah, you're just watching. You're not appearing.
That's correct.
Thank you very much.
Just to explain, perhaps I'll explain once the introductions have been made very briefly. Mr. Montague Smith is aware of our interest.
Thank you. Good. Well, as soon as Mr. Montague Smith is respectable, he'll come to mine, and then Ali will make the usual announcement.
But I was going to say that could take longer than we have, but I'm afraid it's rather dark here as well, so it looks like I'm operating from a green room. But there we are.
Very good. Thank you, Ali.
Thank you. This hearing is in the matter CFI 054 of 2020 and is being held by way of video conference before Justice Roger Giles. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on Justice Roger Giles's instructions. The claimant is represented by White & Case. Lead counsel is Tom Montague Smith QC. The defendant is represented by Al Tamimi & Co. Lead counsel is Patrick Dylan Malone.
Thank you, except I think there might be a correction that, as I understand it, Mr. Malone, I beg your pardon, I called you something else earlier, is not in fact appearing, but just observing. If that is correct, you might confirm that again, Mr. Malone.
I think perhaps appearing is better description. Our position is that we are neutral in the sense that we are neither supporting nor opposing the application, and we will abide by the order. The particular reason we wish to listen in is simply to see if there's any aspect of confidentiality that we wish to address you on at the conclusion of the hearing, in order that any directions might be made in that regard. And Mr. Montague Smith is aware of that. But apart from that, I do not anticipate making any submission. So whether I am appearing or observing, I'm not sure, but I would have thought appearing would be the more correct.
Yeah. Well, it almost certainly won't matter, but I think that is so. If you are retaining the ability, although you don't expect to exercise it, to put a submission to me, then I think you are appearing.
Yes, indeed. Thank you, Justice.
Yeah. Yes, Mr. Montague. I've read the witness statements. That's Mr. Ujo, and there's the recent one of
Al-Qawaja.
Yeah. Yep. I take it that the witness statement of Mr. Hamid Ali is also before me without worrying too much about who actually reads it. Is that correct?
It is, yes.
Yes, thank you. In that case, and I've also read your skeleton argument. I have skimmed through the exhibits, the witness statements. I'm not too sure that an intimate knowledge is going to be necessary, but I don't have an intimate knowledge. Nor have I really gone to the cases in your authorities. So that's where I am.
Thank you, Your Honour. And you would have seen then that this is a claim for Norwich Farm Call relief against Nasdaq Dubai. You've heard from Mr. Dylan Malone, and he's very helpfully explained that Nasdaq Dubai takes a neutral stance. If you're on and I'll take you through it, content to make the order, there are a couple of relatively minor differences between us on one or 2 points, and I will hope to present those fairly. That there's a difference on the cross undertaking and damages, and Mr. Dillon Malone also wants his costs, and I'll come to those at the end of it, if I may. I think I've also spotted a couple of issues with the order, and you may have seen that we have only been, that is my solicitors and I have only been instructed relatively recently, and so I do apologise for the lateness of the bundle and the skeleton as well, but that was the reason why. So, Your Honour, if you have read through my skeleton, you will have seen that the focus of the claim is on 3 trades which took place on the Nasdaq Dubai exchange in February of this year. And so at the heart of this are those 3 trades, and each of those trades was entered onto the system in the opening 1 or 2 seconds of what's known as the pre-closing auction. And so that is a particularly important period for the trading, because it is the period in which the closing price of the shares is ultimately determined. And each of these trades was entered in extremely small volumes at a price which was less than the prevailing best bid. That is, it was at an offering to sell shares in the first claimant at a price which was lower than the price which is already on the system as being offered. So there was no obvious, and there is no obvious commercial explanation for those 3 trades. And they appear quite clearly in our submission to have been attempts to do what's called marking the close, which is to artificially manipulate the price by entering timed trades at the particular moment, the critical moment. And the aim appears to have been artificially to decrease the share price in the first claimant, Emirates REIT. Now, there is a wider concern, and that is that these 3 trades may have been part of a wider attempt to discredit and ultimately replace the second claimant, which manages the fund. And I will explain something of that to you. And there is evidence, we say, that third parties have been engaging in some fairly cloak and dagger tactics in order to unsettle investors, in particular on investor calls. And there's been a degree of coincidence in the timing of these 2 strands, which we say may well indicate that they're connected. So that wider context, we say, lends some greater significance to these 3 trading events. However, it's ultimately these 3 trading events which are the main focus of this particular claim. And you may have seen that trading of this sort on Nasdaq Dubai is anonymous, in that the names, identities of the traders are kept confidential. Now, Nasdaq Dubai has told us that the trades were placed through UBS London, but they were placed on behalf of someone else. And Nasdaq Dubai has been told, and so knows, the identity of the parties who placed these trades, but feels it's unable to tell us who those people are because it says the information is confidential. So what we have is a situation where, from the claimant's perspective, we know that, well, we have a very strong case, we say, that wrongdoing has been carried out, and that the claimants are victims of that wrongdoing, but they are unable to take action against the wrongdoers because they don't know the identity of the wrongdoers. So, and that information, that piece of the jigsaw, is held by Nasdaq Dubai. So we say these are the classic circumstances, really, in which the law calls for Norwich Pharmacal orders to help parties vindicate their legal rights. So what I propose to do to you, for you, Your Honour, today was to take you firstly through the facts, and you'll have seen them broadly, so I'll move relatively speedily through those. But it's important that we deal with this carefully because the people affected by this order aren't here, the traders themselves. So I do need to explain things fairly carefully. And then I was going to deal with the legal test and how it applies in this case. I would hope that I can do that all in about 45 minutes, and so I won't trouble Your Honour for too long on this. But obviously, if there are issues that arise along the way, then as ever, please do interrupt me and ask me questions. Your Honour will have seen the background of from the statement of Mr. Veugeot, and there has been, as you said, as you've seen, a recent update in the statement of Ms. Al-Khawaja, which deals a bit more with the background, the context. And Your Honour may have seen, just as further background, that the first claimant, Emirates REIT, is traded only on Nasdaq Dubai. It was established in June 2011, and it's always been managed by the second claimant. Now, since that time, it's grown quite considerably from a net asset value initially of 68 million to a peak of about $531 million. So this is a substantial enterprise now, and by March of this year, the net asset value was around $422 million. Now, amongst its shareholders were various funds belonging to a group called Lazar. And one of Lazar's fund managers, a man called Mr. Fadi Al-Said, participated in the fund's AGM back in June 2019. And during the course of that, he asked a series of questions, which included some highly critical allegations being made against the fund manager. Now, we don't repeat those allegations in this case for obvious reasons, but the claimant's position is that some of the allegations that were being made on that call were false and damaging. Then there was no action was taken, as I understand it, in relation to that, but then the reason why that becomes significant emerged subsequently after the three trades which occurred. The three trades themselves are the next event in time, which took place, the first one on the 5th of February 2020. Now, the best place to see what happened here is by looking at one of the exhibits to Mr. Veugeot's witness statement, which you'll find. Sorry, can I ask everybody else who's on this call, please, just to mute themselves? There's one guest who's got, thank you very much, apologies for that. So if Your Honour has access to the bundle, and could turn up, please, section 1, and turn to page 8 of section 1, which you should find behind tab 3. This is an exhibit to Mr. Veugeot's, sorry, I do apologise, page 24. This is an exhibit to Mr. Veugeot's witness statement. And what you see here is the complaint that was made immediately after the day, on the day of the trade, immediately after the trade took place. And what you can see on page...
Hold on a second, if you don't mind.
Of course.
As usual, the equipment is acting up. I was logged in, but it logged me out again. Right, now I have the e-bundle again. Where am I going to in that, please?
So it's volume 1, and it's page 24.
Right.
And if you see there a letter,
yep,
which you should see at the top, is dated 5th of February 2020. So that's the day of the actual first material trade. And what I'm asking you to look at is the box, which I think is a selection from a screenshot taken from the system. And you can see there on the left 2 columns, the buy orders under various under various rows, and then on the right you see the sell orders. And so the sell order on the right at the top on column 1, you will see rises to the top because it's the lowest sell order, and you see it's a very small number of shares, 110 shares being offered for sale at 37.7 cents, $0.377. But at the same time, you see there was a buy order of 25,000 shares on the books at 39 cents. So then what you've got is a tiny trade compared to all the other trades of the day, at a price which is lower than the best prevailing bid. And you can see the timing, and the timing becomes important for as I'll explain. Over the page, you see the timing of the trades. And if you look there at the first box at the top, do you see the times going down? And if you can find the third row, you'll see it at 1:45 p.m. and 1 second, so 1 second into the closing auction, you can see the sell offer at 110 shares at it's recorded at 384. And the reason for that is because of the way in which the prices are calculated during the pre-closing auction. But in any event, you can see that the bid is entered at 1 second into that auction, and then it completes at 1:55 p.m., which is the close of the shortly after the close of the pre-closing auction, at 384 cents. So there are two things to note in relation to this bid. The first is that the timing is significant. So I've said the pre-closing auction starts at 1:45 p.m. Now, and so 1 second afterwards, you've got this bid. And the significance of the auction period is because that is when the closing price is set. And what happens, and I can show you this in the material if you like, but parties during this period, they enter trades onto the system and they're not executed immediately. And as a result of the trading during that period, the system generates what's called the theoretical auction price. And there's an algorithm which looks at trading history, but in particular at the trades which occur during that period. And then it sets the price based on that, and that becomes the closing price for the day, and is also the price at which the trades are executed at the end of the session. So that's why you've got the bid at the offer bid at 377 gets executed at 384, because the effect of that bid on the price is to cause a calculated price to emerge, which then is the price at which they're executed. So I can show you that in the rules if it's helpful for me to do that. I'm happy to show you that in the Nasdaq rules if you'd like me to.
No, I understand that is the system.
Now the rules have now changed, and so the rules that we have in the bundle are slightly different to the ones that were operating at the time. And the way in which they've changed is that the Nasdaq Dubai has now introduced a minimum bid for real estate funds, and that is of $3,000. So that came into effect after the trades. At the time, the result that was that the price could be affected by very small bids of this sort, particularly because in relation to this stock, you had quite an illiquid stock. So there are not a large number of trades being entered in any particular day. And it's quite possible, as was the case on this day, that the only bid in the pre-closing auction would be the very small bid, which I've referred to. And in fact, on that day, I think there were only 9 trades throughout the whole day. And so in this case, we've got this very small bid timed for 1 second after the pre-closing auction began. And so we say it's a reasonable inference, strong inference, that the timing was the critical reason for the trade. So the sell price was lower than the prevailing bid, and the effect was a closing price which was lower than the previous price which had been noted, which would otherwise have formed the closing price. So we've seen the trade being executed at the theoretical auction price of 384, but absent the trade, if we look back at that schedule, you'll see the previous trades prior to that were at 41 cents. So the last traded price would have been the price, but the effect of this bid was to lower the price to 384, which reduced the value of the stock on the exchange by about 6.3%. There was then a similar event on the following day, and if we go over the page to page 26, you can see some aspects of that. I won't take you through every single one of them, but what the evidence shows is that on the next day you had a sell trade, again, this time for 365 shares, and that was entered 2 seconds after the auction began at a price of 346. So the prevailing bid at that time was again 39 cents, so quite significantly lower than what could simply have been obtained just by offering to sell at the prevailing bid price. And then again, a little bit later, there's a short gap, but on the 13th of February, you have another event of this sort, 1 second into the pre-closing auction, and on that occasion, you had 257 shares being offered for sale for 36 cents. And on that occasion, the prevailing bid, the best bid, was 39.5 cents. So about 9%, 8.9% lower than the prevailing bid. And that's all covered in Mr. Veugeot's witness statement. So those are the three. I would go further than saying they're suspicious trades. We would say that there's a clear inference that these were intended to lower the market price. And I'll come on to the legal consequences of that in a moment. But just to finish off on the factual background, I mentioned Mr. Al Said's intervention in the June 2019 AGM. But shortly after these trades occurred, Mr. Al Said then got in contact with the fund's largest investor, and you can see a report of what was said in the same exhibit if we go back to page 20 of that exhibit. So you'll recall that the last of the trades was on the 13th of February, and then following that on the 12th of March, so just under a month later, we received this email, or the claimants received this email from the largest shareholder of the fund, and you will see what said. Sohail got a call from Lazar Asset Management in DIFC, inviting him for a discussion on some issues related to REIT fund. I told him about the call and I advised him to meet the representative. And you'll see there's a reference to Mr. Fadi from Lazar just above that. Now he then makes some allegations against the fund and the fund manager. I'm not going to read those out, but you can see there what is being said. And again, the claimant's position is that these allegations are, insofar as they are critical, not accurate. These are false allegations. So then on the 18th of March, if we go forward 2 pages, we see another email from the same shareholder. About halfway down the page, you'll see Dear Abdullah, and this is where we find out about the introduction of a DIFC fund manager called Dalma Capital. You see, he says, Dalma Capital Limited is the second investor of Emirates REIT who has requested a call upon DIB. I believe there is a link contact with Fadi from Lazar Fund. I asked Sohail to have a conference call with Mr. Zachary from Dalma Capital on the subject of Emirates REIT. A call took place yesterday, and the main points raised as follows. And again, you will see 1, 2, and 3 some criticisms of the fund and the manager. I particularly ask you to note paragraphs 4 and 5. 4, Dalma was asked if it had any financial interest in the fund, and if so, what is their shareholding? The response by Zachary was that they are activist and in touch with other shareholders of the fund. And 5, the objective is to install new REIT manager who is more efficient in managing the portfolio. They are exploring buying out a REIT manager's right, as well as stake of any potential shareholder in the REIT fund. So they describe themselves as activists and in touch with shareholders, and their objective is to replace the fund manager. And then finally, in terms of the facts, sorry.
That's right. Can you help me on who these emails were to and from?
Yes. So you'll see what you get was so that the largest shareholder in the fund. So in the middle of the page on page 22, you'll see it's an email that's an internal email from that inside that shareholder, and then that is then passed on, I believe, to Emirates REIT. Subsequently. But this is an internal email, I think. Yes, so you'll see at the top from Adnan Al-Sharif, who's the investment banking. And if you look above, you can see above that his email address is a DIB email address. So that's from the shareholder itself, and then he's sending that to other people within that bank.
Right, so Mr. Al-Sharif is effectively the largest shareholder.
He is in the investment arm of that shareholder. It's DIB as the shareholder.
And he's received which comes first.
So previously on the 12th of March, he's been approached by Mr. Al-Said from Lazar. And again, that report that I showed you on page 20 is also an internal report, which was subsequently forwarded on to the claimants. But these are the investor is the people within the investor are emailing each other, and then subsequently he's then received a further approach about a week later, this time from Mr. Zachary from Dalma Capital.
Yes, thank you. I have it. Good.
Thank you. And then there's a bit of a gap, but then we have this. You may have seen this, a very strange event which took place in September of this year on an investor call. So the fund held an investor call, and investors were invited to ask questions, and it was a Zoom call, and so they were using the Zoom chat function. So it wasn't a video questioning session. And what happened is another individual called Mr. Lahori started to pose questions on this call, and those questions are recorded in a report which was prepared by Kroll. And I'll just show you very briefly because it's worth we're having to do a little bit of detective work here, but to piece it all together, if you could turn please to section 4 of the bundle and page 17. What you're looking at is a Kroll memo.
Just give it a moment to load, please.
Of course.
Yes, I'm at page 14.
Thank you. So it was 17. Maybe my fault.
I'm there.
Thank you. So what you see there is a record of the various questions asked by two people on the investor call, and one of them was a Mr. Lahori, and he asked 10 questions. And question number 4, I'll ask you to read to yourself, Your Honour.
Yes.
And then what happened was another individual was also on the call, identified themselves as a Ms. Angela Shen, and you'll see that she also asked a number of questions, or that individual anyway also asked a number of questions, and she asked, or that person asked 6 questions, and you will see just by a cursory review of those questions put against Mr. Lahori's questions that they essentially matched the content of the questions that he was posing. And what Kroll has done is they've done a bit of an investigation into what was going on here, and they've discovered that there is a Ms. Angela Shen, but she works for a global commodities trader in Singapore, and she has always been based either in Singapore or Hong Kong. So she has no obvious links with the Middle East or with the real estate investment, but of more direct concern, the individual who registered for the call and identified themselves as Ms. Shen was registered using the email address of a lady called Sophia Weininger. And Miss Weininger is the fiance of Mr. Zachary Seferati, who was the individual from Dalma Capital who approached the shareholder back in March. It's also apparent that Mr. Seferati and Dalma Capital are connected to Mr. Lahori. In particular, we know, I'll just wait for you to finish your notes, sorry.
Yeah.
We know that Dalma Capital is the fund manager for another real estate fund, of which Mr. Lahori is the director and shareholder. And in fact, Mr. Seferati is a director of that fund and is Facebook friends with Mr. Lahori. So we can only see part of the detail, but what appears to be clear is that there is a coordinated effort between a number of third parties, which by their own account is aimed at replacing the fund manager. And what we say is that it looks like the efforts are being undertaken, at least in part, in a way which is intended to conceal those connections. Now, some of that activity, we say, because of the connections between Mr. Al-Said, who was connected, it appears, at least in time, and according to the shareholder, to Mr. Seferati and Dalma Capital, who's connected to Mr. Lahori, and also to this individual identifying themselves as Ms. Shen. Some of that activity was happening around the same time as the trades. Now, I don't go so far as to say I need to explain to you, or even set out a good arguable case that all of these individuals were undertaking those trades. We simply cannot say at this time, but just using common sense, the timing suggests that there may well be a connection. Now, in terms of the hard merits of the application, I'll come on to that now. I don't need to rely on the wider context to establish, for example, what I need to in terms of the merits, the good arguable case, because I can show that there's a good arguable case of market manipulation by the unknown trader, and that should be sufficient for those purposes. But it's significant, as I've said, because it emphasizes the importance of these events to both the fund and the fund manager. And so when we come on to the sort of... Sorry, I think we've lost the judge.
Oh yes, we're just looking into that.
Thanks.
Right. I have reconnected. Mr. Montague Smith, have you again?
Thank you. Yes, I've got you.
The
So
last thing, you were just saying that you didn't need the wider case, but because you had a good case of market manipulation, that's where things fell out.
Thank you. All right. Well, I was going to then just turn briefly to the test for Norwich Pharmacal Relief, and then deal with each element of that test. And in the course of that, I'm going to show you what my case is in relation to market manipulation. So the first then aspect of this is, what are the circumstances in which the court can make this sort of order? But taking a step back from that, it's worth just pointing out that this court has recognised the Norwich Pharmacal jurisdiction in at least 2 cases. The only reported case is the Cash Plus case, which was a decision of Sir Anthony Coleman quite early in the development of the DIFC court. That is in the bundle. I don't think I need to take you to it unless you'd like me to. But in that case, it's worth saying relief was, I think, initially granted and then set aside, so ultimately refused by the judge. But the principle was recognised as being applicable. There have been other cases, I'm personally aware of other cases, in which Norwich Pharmacal Relief has been granted. And in at least one of those, that was in circumstances not dissimilar to this, albeit it's a sort of more classic case where the disclosure order was being made against a bank who were mixed up in the wrongdoing because money had passed through accounts held with them. But I think, unfortunately, because of the way in which the order was made in that case, there was no reported judgment on that. And so from a practitioner point of view, if you're on have the time to do so, I would simply say that a judgment on this sort of issue would be of considerable assistance to court users. But obviously, I know that there are plenty of demands on judicial time, so I'll say no more than that. Effectively, there are 3 conditions which must be met before the court can accept and issue an order of this sort. If those 3 conditions are satisfied, then there is a multifactorial assessment of whether or not making the order is in the interests of justice. The test was relatively recently summarised by Mr. Justice Flo, as he was in the Ramelos trading case. If Your Honour has section 7 of the bundle and goes to tab 10 and page 327. Sorry, 326 it is. So you'll see there the 3 conditions to be satisfied for the court to exercise the power under the Norwich Pharmacal Relief are: number 1, a wrong must have been carried out or arguably carried out by the ultimate wrongdoer. There must be the need for an order, so it needs to be necessary in order to enable action to be brought against the ultimate wrongdoer. And the person against whom the order is sought must be mixed up in so as to have facilitated the wrongdoing and be able or likely to be able to provide the information necessary to enable the ultimate wrongdoer to be sued. And it's really in that 3rd step where the Cash Plus case failed, because there was insufficient evidence that there was an account, that the wrongdoer had an account with the bank, and so there was insufficient evidence to show that the bank was mixed up or had the information. Now, if those conditions are satisfied, and firstly, if we go over the page to page 327, you'll see at paragraph 14, there's discussion about what it means to have an arguable case. And the test there at paragraph 14, you'll see, it is the good arguable case test that you see in the test for freezing orders in particular.
Did Sir Anthony Coleman suggest that there was a slightly stronger test than that? I did look at that case earlier.
No, I'll show you. I think what you're thinking of is what he says is in Cash Plus, there needed to be, on the balance of probabilities, evidence that in that case the bank had an account in the name of the wrongdoer. So he was looking at a different element of the test. Cash Plus, we can see that in tab 6, and I believe it's paragraph 14 of that. Yeah, so it's at page 203. It looks like he's saying something slightly different, but when you actually read what he's saying, he's dealing with a different aspect of the test. So paragraph 14, he says, do you have that? In order to obtain a freezing injunction, the claimant is required to demonstrate a good arguable case on the underlying claim, where on a without notice application the claimant seeks an order for disclosure against an innocent outside party such as a bank, there must be a more demanding standard of proof than that of a good arguable case. So I can see where the confusion could arise, because it does look like he's talking about the underlying case. But he says this then: the correct test in my judgment is whether on the balance of probabilities the defendant maintains accounts at or keeps assets with the outside party. And then says to deploy a less exacting standard of proof would not adequately protect banks and other financial institutions from invasive and ill-founded demands for what may turn out to be time-consuming and inconvenient searches, or would at least force an outside party to appear in court to get the order against it discharged. So if you think about what he's targeting there, he's talking about the question of whether or not the defendant maintains accounts or keeps assets with the bank. And that, as I say, goes to the question of whether the bank is, quotes, mixed up in the wrongdoing, or alternatively, and also as to whether it has information that would assist. So, in fact, what he's saying is that there needs to be a stronger standard of proof in that aspect of it. Now, in this case, we know, and I'll deal with it in due course. But it's clear that it's admitted by Nasdaq Dubai that they are, quote, mixed up innocently in this conduct. Why? Because they are the exchange on which the trades were transacted. Now, if Your Honour disagrees with me and suggests, well, actually, the initial wording of the first sentence is what governs, because he does say it has to be a more exacting standard of proof, and does seem to be saying that needs to be applied to the underlying claim, then I say I can show you a more I can meet that higher standard if I need to, but I do say that would be a wrong turn for this jurisdiction for two reasons. Firstly, I don't think that is what Mr. Justice Coleman is in fact saying in that, and secondly, that would be completely inconsistent with the clear approach taken in English law on which this jurisdiction is based.
Something like that.
So as I say, if those, I've shown you those three conditions, as I say, if those three conditions are satisfied, that's not the end of it. The court then has to decide whether to make the order in the interests of justice. That's described in some places, including in the Ramilos case, which I showed you, as being a discretion. That is probably not right. It's probably one of those cases where it's a multifactorial assessment. So a bit like determining whether it's an abusive process. It's whether or not making the order is in the interests of justice. It's a fine distinction, doesn't much matter. The authorities have identified a series of considerations to be taken into account when you get to that stage, and I'll show you that and deal with each one at that later stage. What I was going to deal with first, though, is this issue of the merits of the underlying claim against the trader. And so obviously we say we have a strong case, a very strong case, against the trader or the traders, if there are more than one, who entered those 3 trades on the system. The best way to do this, I think, is probably for me to just take you through what I say about it in the skeleton argument, because I've recited certain aspects of the legislation in that. If you have my skeleton at paragraph 40, which is on page 8 of the skeleton, we can look at it starting from paragraph 40. You'll see what's defined as market manipulation, which is prohibited by Article 54 of the DIFC Markets Law, and that is defined to include conduct which a person knows or reasonably ought to know creates or is likely to create an artificial price for one or more investments. The DFSA has issued a code for market conduct. It's not legislation as such, it's guidance as to what the DIFC considers may contravene the provisions of that article. And at chapter 2-2 of that code, you see I've recited the relevant section, paragraph 3A, on paragraph 41 of my skeleton. That includes marking the open or marking the close. That is buying or selling an investment near the reference time of the trading session, e.g. at opening or closing time or at the end of a particular period, in order to increase, decrease or maintain the reference price at a specific level. And so for the reasons I've explained, we say it is highly likely that the trades were all attempts at or actual successful market manipulation. And I say that flows in particular from the prices, because they were being offered at a price lower than was being offered by purchasers. The timing, because they came 1 or 2 seconds after the start of that particularly sensitive price fixing period. And also the multiple occasions on which that has happened indicates that it's not just some slip of a thumb, it's a deliberate strategy that's being pursued.
Well, let me pursue that is so. What I would be interested in is what right then that either of the applicants is vindicating.
Yes. So the breach of this sort of legislation gives right to firstly a right to claim compensation for loss, and secondly a right to restrain the conduct by injunction. That flows from the regulatory law. You will find the regulatory law in the same section of the bundle, section 7, and so you can see it at 7 tab 2 page 143.
We don't need to go to that because I quite accept that, but yeah. What is the position of the 2 applicants in that regard? First of all, it doesn't leap out to me that at this point in time they would have any chance whatsoever of getting an injunction. And secondly, I'm not too sure that they have suffered loss.
Well, it seems to me that I can't show you what the loss is, but we've seen from the first trade in particular that the effect of that trade was to reduce the value of the company and reduce the trading value of the company because the share price was artificially reduced. So if the company is not in a position to take action in relation to that, then outside the DFSA, it's hard to see who would be in a position to be compensated for that. So we say the company has suffered loss. You can see that, for example, the obvious party who might... Sorry.
The ones who might suffer are shareholders or people who have, shareholders who've had to sell at a lower price, for example. But the applicants don't hold shares in themselves.
No, that's right. But one can see that actually the opposite would be arguable, at least, because what is the shareholders claims would likely fall foul of the principles relating to reflective loss, because ultimately what it would be said is that the reduction in the value of the company is a loss of value suffered by the company, and the shareholders' losses are simply reflective of those losses by the company. So
that is, no, hang on, but that's where the company has suffered a loss of an asset, for example.
yeah,
Asset of the company has been damaged, therefore the company is worth less. Now that's not our situation. I'm debating this here considerably with myself.
Well, I can see that. I think that the loss is twofold. If you don't accept that the company itself is suffering loss, then the fund manager is itself suffering loss, which is affected by the share price of the company, because it's going to be suffering loss of remuneration as a result of the valuation of the company being reduced. Its valuation is its fees are set by reference to the performance of the company, and so if the performance of the company is reduced, then so will its income in relation to that. It is also the case that you have seen the evidence. This is why the wider context becomes important.
Hang on, we keep away from the wider context.
Understood.
When you say, for the moment, that is, when you say the fees are set by reference performance, now what does that mean? That does not necessarily mean share price.
Well, it's by reference to the net asset value, and you will have seen in some of the. Well, that's why I have to go to the wider context to explain this, because you will have seen that.
I'll keep away from the wider context for the moment.
Yes, but you've asked me a question which impacts on it, because quite a lot of the questioning was by reference to the trading price being separated from the what was said is that the shares were trading at a price which was lower than the net asset value. So you see, even if there's no direct correlation between the two, what you've got is, as the share price comes down, pressure from investors and these activists indicating that the net asset value ought to be lower, and so it's a reference point, is my point, by reference to which the net asset value and therefore the fees of the manager are to be assessed.
I don't follow that. The net asset value, it holds real estate, as I understand it. And the real estate is worth however many dirham it's worth. What it's worth may affect and would affect the share price, but it's not the reverse. Not that I can see.
But it's not going to be as direct as that, though, is it? Because it's not just simply a collection of assets. It's a business which relies on, amongst other things, financing and so forth, which in turn will be affected by the market capitalization of the company. So if I go to the bank and I say, well, my net asset value is this, and because I valued my collection, my portfolio of assets at this rate, now we want to make acquisitions requiring us, which will affect the ongoing business, then you can see that the performance of the company going forward is clearly going to be affected by the market capitalization that can be presented to a bank, and that's going to be directly referred to by reference to the price at which shares are trading. It's not simply a question of saying, well, we've got a bag of assets here, what is that worth? Okay, because then there would be no trading. It would just simply be a question of valuing the assets and saying, well, that's therefore the price of the shares. The very fact that you can have a difference between the net asset value and the share price, it demonstrates that you're dealing with a company whose fortunes and therefore who the manager's fees will be affected by the market capitalization. The other point is that
any specific evidence as to the fee basis for the manager?
we don't. I do have Mr. Sylvain Vigeot on the telephone. He can speak to that if you have concerns about that, and I can ask him to give some evidence in relation to it. But that's, as I understand it, the first aspect of this. Now, you will also have seen in the evidence, the other aspect of it is that the fund manager owes fiduciary duties to the shareholders. And so the other aspect of it is that the fund manager is empowered and able and has duties to take action to protect the investments of the investors. So if Your Honour accepts that the investors are themselves would have an interest and could be harmed by a reduction in the value of the shareholdings, if that part of it is accepted, then it is the fund manager who has the duty to take action in relation to that, effectively on behalf of the shareholders.
What action is that?
I'm sorry?
What action is that?
To prevent it from happening again.
We're at injunction thinking, are we?
Yes.
Right.
But it seems to me, yeah.
But injunction, there were 3 instances back in March.
Yes.
There's no evidence of anything having happened since by way of market manipulation.
Correct.
Really, I repeat, I really can't see that there'd be the slightest prospect of getting an injunction at this point.
Well, if Your Honour's taken, I mean, it's difficult to deal with that if Your Honour's already decided it. I mean, I think that...
I haven't decided, I'm putting for your comment, but it is a, what you might call a fairly firm tentative view.
Well, I question how that can be right. I mean, one's got a situation where, assume you accept that there's a clear case that these individuals have sought to and have managed to affect the market price of this company in a way which is real. I've shown you that it reduced the value of the company by 6.5% on the first occasion. Now, assume